Our courts regularly resolve disputes involving loss and injury caused by negligence. Courts know how to decide disputes in a fair, public, and responsible manner. Appellate courts exist to correct errors. What do we know about the Gulf oil spill? On April 20th, 2010, a blowout and explosion on the Deepwater Horizon killed 11 workers and injured 17. It became the largest marine oil spill in history. Estimates of the total amount of oil spilled vary widely. The forecasts of the ultimate environmental damage and the total economic injuries remain unknown. Who are the actors in this disaster? Transocean owned the rig. The rig was leased to BP, and Halliburton was operating the rig. But what don't we know? Well, what exactly happened and why? What was wrong with the blowout valve? Who manufactured it? How old was it? When was it last tested? Was someone negligent or grossly negligent or reckless or wanton? The courts would normally ask each of those questions and many more to witnesses sworn to oath at public trials. The evidence would ultimately determine who was responsible and the fair and correct measure of damages and the amount of damages. But not this time. Not if BP has its way. BP promised $20 billion to help everybody. That sounds like a pretty good idea at first blush. But as of Monday, August 23rd, less than 2% of that money had actually been paid out to anyone, which explains why so many people are still suffering. And our courts have been pushed to the side, bypassed in favor of a brand new agency, the Gulf Coast Claims Facility, which is run by one man, a Washington, D.C. lawyer, who recently declared, quote, "If I don't find you eligible, no court will find you eligible," unquote. Well, how in the world could he possibly know that? There are still so many unknowns about what caused this disaster and how bad the damages may ultimately be. He thinks he knows the answer because he makes up the rules in this new facility. And rule number one is that anybody accepting money will be required to waive their constitutional rights to their day in court, to the right to have a jury decide the facts, the right to discover the truth, and the right to a public trial. And rule number two is that anyone who accepts money will waive their claims against BP, Halliburton, and everybody else. There'll be no discovery, no public trial, no witnesses, no evidence, and we may never know what really happened and who was really at fault. BP is trying to avoid the law. It's trying to use its money, $20 billion, to buy its way out of trouble. It's asking the many hundreds of thousands of victims of this disaster, many of whom are now desperate, to waive important rights in exchange for some immediate compensation. The government agencies who are responsible for inspecting and regulating and maintaining enforcement of safety on these rigs, they like the idea because they'll not be subject to any public examination by the courts either. This is a classic example of private justice, of big money trying to step up above the law. It's just like your bank or your credit card company and your cell phone company insisting that you waive your constitutional rights and agree to arbitration before their hand-picked arbitrators in order to get service. My name is Matt Wilson, and I'm running for the Supreme Court of the state of Georgia. I believe in our Constitution. I believe in our courts and in our laws and in the ability of our courts to find the truth and to fairly apply the laws. I don't believe anyone should be above the laws. Thank you.